Hello guys. So today what are we going to do? We are going to discuss. I know your exam is near. It's hardly another 2 days to go. So I just thought at the last moment, because of in the past attempts, whatever is your mock test papers, your model test papers that has been given by the institute, there are high chances of the questions coming from those model test papers. We know that fact as well. So what I thought of doing, I thought of solving all the model test papers, whatever I can, with having the time also in mind. So let's begin. I'll at least try to solve 5 model test papers in this session. So just sit back, relax, make a note if there is anything that you guys want to do it. I'll also vaguely try to tell you how to present the question in whichever is being asked. So this is what I'll be able to do, and just sit back, relax. Before the exam, a good 80-90 questions revision is the best thing that can happen with regards to law. So keep that in mind, and yes, let's start. Okay, the first ones are, let us start. Let us try to focus on the indirect questions. I know direct questions you guys can handle it. Indirect questions is where you guys would need help. So let us focus on that. Kashish was running a business of artificial jewelry since long. He sold his business to Naman and promises not to carry on the business of artificial jewelry and real diamond jewelry in that area for a period of next 1 year. After 2 months, Kashish opened a showroom for real diamond jewelry. Naman filed a suit against Kashish for closing the business of real diamond jewelry business as it was against the agreement. Whether Kashish is liable to close his business of real diamond jewelry following the provisions of Indian Contract Act. So what happened in this case, people? There were two people, Kashish and Naman. Kashish has said that Kashish was running a business of artificial jewelry. He sold artificial jewelry business to Naman. But while signing, he said, I'm giving you artificial jewelry. In the future, I'm not even going to start artificial jewelry or real, jewelry business, because it is going to be competing. Now, the question is, if Kashish tomorrow starts, even after signing a contract, Kashish is starting a real jewelry business. He has signed that I'm not going to start the real jewelry as well as artificial jewelry. But if he, in fact, after signing the contract, if he actually starts the real jewelry business, whether will it be considered as a breach of contract? Whether will Naman have any right over Kashish? Now try to think. Now people, whenever I say that you cannot, carry on a competing business, whatever you have sold, you cannot carry on the same business. The restriction always applies to the same business, people. That is artificial jewelry. With regards to the, real diamond jewelry, there is nothing that we have agreed, there is nothing that I have been doing in my real life. So remember, whatever is considered as anti-competitive, it will always be only for the business that I have been doing and whatever I've sold to you. With regards to the real life, that is nowhere covered in this particular scenario. So the answer is, people, no, the real life business will not be considered as a breach of contract. The person, Kashish, can carry on the real jewelry, that is real diamond business. That is what they would have said. Section 27, any person is restrained from exercising a lawful profession, trade or business of any kind is to that extent void. So you cannot restrict any person from carrying on a trade forever. I hope you guys know. But for a reasonable period, it is valid. In this reasonable period, you can expect a lot of question. They will say that, imagine Kashish said, I have, the shop is in, say, for example, Bangalore area also, let us imagine, area called MG Road. Yes, if Kashish says that I'm not going to carry on the artificial jewelry business forever in MG Road, is this considered as valid? Is it reasonable restriction or unreasonable restriction. This will be considered as reasonable only. I'm only stopping you from doing a business in one area in one city. So this is a reasonable restriction. You can such type of questions can come from this particular thing. So remember and go. Provision is important. So what does it say? The local limit within which the seller of the goodwill agrees not to carry on similar business must be reasonable. So in our case, it's not reasonable because that is not something which I have sold you. The business I was not doing at all. So see, is applicable to similar business only. So it's only artificial. Agreement between Namman and Kashish will not be applicable on business of Real Diamond. Hence, Kashish can continue. I hope this is clear. Simple. Okay, next one. The paid up capital of Darshan Photographs Private Limited is 1 crore in the form of 50,000 equity shares of 100 each and 50,000 preference shares of 100 each. Shadow Evening Private Limited is holding 25,000 equity shares in Darshan Photographs Private Limited. So what is there? There is something called as Darshan Photographs Private Limited. In this people, they have 50,000 equity shares and 50,000 preference shares. That's their capital. In this, what are they telling you? Shadow Evening Private Limited is holding. There is one more company called as Shadow. Now they are holding how much people? They are holding 25,000 equity shares out of this 50,000. Equity shares in photograph and state with reason whether Darshan Photographs Private Limited is a subsidiary of Shadow Evening Private Limited. That's the first question. Whether your answer will be different. First we'll answer this. Now people, out of 50,000, Shadow is holding 25,000. Is this considered as a a subsidiary company? First of all, now when I'm defining, I need to define what is a subsidiary company. 2 clause 87 says what? A subsidiary company is a company in which a company holds more than 1/2 of the total voting power. People in equity and preference, to help you guys in the exam, they have clearly said the preference share does not have voting rights. So only equity has voting power here. So out of 50,000, they are having how much people? 25,000. That means what? They are exactly holding 50. When will a company become a subsidiary company? Whenever a company holds more than 1/2. That means what? You should hold at least 25,001 share. That is when it becomes more than 1/2. In this case, it is exact 25,000. So no people, it will not be considered as a subsidiary company. Whether your answer would be different in case Shadow Evening Private Limited is holding 25,000 equity and 5,000 preference share. My answer wouldn't change. Why? Because what is a subsidiary company? A company in which other company holds more than 1/2 of the total voting power. Preference shares will never have voting rights. So still they are holding 25,000 only equity. So on this ground, people, no, my answer wouldn't change. I hope this makes sense. Clear all of you? Good. Kapil entered in a contract with Rahul to purchase 1,000 liters of mustard oil at the price which should be fixed by Akhilesh. Rahul already delivered 600 liters out of 1,000 liters to Kapil, but so Rahul agreed to sell to Kapil how much? 1,000 liters of oil it seems. The price will be fixed by Akhilesh. So technically, Sale of Goods Act, when the price, that is what is the question. Rahul already delivered 600 liters. Rahul has delivered 600 liters it seems. But when remaining 400 liters was ready to be delivered, Akhilesh denied giving the price. Rahul asked Kapil to return the oil already delivered and avoid the delivery of 400 liters. Kapil sued Rahul for non-delivery of remaining 400 liters mustard oil. Advice in the light of Sale of Goods Act. People remember the Sale of Goods Act, whenever we are going to decide the price based upon what a third party says. Can we do it in the classes and all? You might have done it as a valuation and all those things. Now, in this case, what happened? Two parties have agreed to purchase and sell the oil, 1,000 liters of oil. Now, always remember, in Sale of Goods Act, the price may be determined by the parties Or they can say a third party will decide the price. We are going to enter into a contract based on the price decided by the third party. Like that also you can enter into a contract. Now in this case what we have done, we have agreed, okay, whatever Akhilesh fixes, that will be the price we have agreed. Now remember people, whenever the third party is not able to arrive at the price, now in such case what we can do? We can avoid the contract, meaning the contract will come to an end. That is what section 9 says. Correct? Ascertainment of a price. Now sir, but remember, whenever a price of a product will be determined by a third party, but before the price is determined, if at all the seller has delivered the product to the buyer, now the third party is not able to derive the price, then remember people, it is buyer's responsibility to pay to the seller whatever is considered as reasonable price. Now you cannot cancel the contract. In our case, 600 liters is already delivered. The price is not determined, but as per section 9, what does it say? If the goods are already delivered and if the third party is unable to fix the price, in such case people, whatever is the price for the 600 liters, that has to be paid by the buyer to the seller. Now again I am telling you, how do we have to present this in the exam? First write what does the law say, section 9. Now first detailedly explain section 9. As per section 9, how do we determine the price of a particular goods? The price can be determined by the parties themselves, or they can determine by the course of dealing, or they can determine based upon the third party. Now remember people, whenever the seller has given or delivered the product to the buyer, now the buyer cannot reject the goods, nor the seller can ask back the goods. That's the rule. If at all the seller and buyer, if they have if they have relied upon a third party to give the price, and if the third party is unable to decide the price, in such case people, the contract can be avoided, meaning you can put an end to the contract. This is what the provision says. However, before the third party decides the price, if at all any goods are delivered, then the buyer has to pay what is reasonable. Now this is what is my provision. Now come and explain it. What is my explanation? I'll be writing the buyer will have to pay the price. In our case, names also will be there. No, we would have used names also. What is that? Kapil will have to pay to Rahul the price what is reasonable for the 600 liters. The rest of the 400 liters, the contract can be avoided. That will be the advice. So Kapil sued Rahul for non-delivery of remaining 400 liters of mustard oil. Kapil cannot sue Rahul for non-delivery of 400 liters as the price was not fixed. So that contract can be avoided. So you can put an end to the contract. Is this clear all of you? Hello? Pakka? Okay. That is this question. Direct ones, go through. A and B are partners in measures A, B and company. The firm is doing business of trading of plastic bottles. A is authorized to sell the stock of plastic bottles. It was decided between them that A should sell the plastic bottles at the minimum price which they have decided, and if A sells at a price less than the minimum price, he should first take the permission of B. Due to sudden change in government policy, the price of plastic bottles were continuously declining. To save the loss of firm, A sold the stock at a lower price. Meanwhile, A tried to contact B but could not do so as B was on foreign trip. Afterwards, when B came, he filed a suit to recover the difference of sale price and minimum price to the firm. Whether B can do so under the provisions of Indian Partnership Act. Now, what is that, people? Always remember, all the partners, what is that they're telling you? Simple, people. B has authorized A to sell. They are into plastic bottle business, partnership. A can sell the plastic bottles at a price which is not less than, let us imagine, 100. But because of some government policy, every day the plastic bottle price is becoming 90, 80. This keep on declining. This kept on declining. Now what happened, people? A has tried to reach out to B. B, what do we do? B is on a foreign trip. So B is not able to receive the call. Of course, because international number. Now what can A do? What did A do? In the best interest of the partnership firm, he sold all the plastic bottles at whatever was that day's prevalent market price. Now B, after coming back from the trip, he is telling A exceeded his authority. Now this is nothing but, people, whatever is the rights and duties of the partners, we can fix it right as per the agreement. Now remember, people, whatever the restrictions are, implied authority, the scope of the partner, it will not apply if at all the partner has acted during emergency. Now because of that, he has acted in the best interest of partnership. So people, B cannot hold A liable. Not applicable. Hello, I hope this is clear. That is what is given now. Every partner has a right to be indemnified by the firm in respect of payments made and liabilities incurred in performance of an act. The in the instance would make incur under similar. Okay, on the basis of the lower price was save the firm. It was to save the firm from loss, as the act of A was in favor of the firm. He was not liable to bear the loss. This is clear, all of you. So in the emergency, whatever, due to some emergency, if at all I am acting, people, then however a person on a normal brain, however he would work, I have worked the same way. I tried to reach the other partner also. He did not respond. In such case, what I will do? I will do whatever is the best. Done. Okay, next one. Tycoon Private Limited is a holding company of Glassware Private Limited. As per the last profit and loss account for the year ending 31st March 23 of Glassware Private Limited, its turnover was 1.8 crore and paid up capital is 80 lakh. The board of directors wants to avail the status of small company. Small company in the light of, okay, people, one thing to remember, small company definition, it's simple. Tycoon is the holding company of glass company as per the product. Okay, remember, people, what do you mean by a small company? A company whose paid up capital shall not exceed 4 crore and turnover not exceed 40 crore. Remember, in small company there is an amendment. All of us are aware of it, but it does not apply for your attempt if you're writing in Jan. If you guys are writing in May or after that, yes, this will be applicable to you. But if you guys are writing in Jan, this will not apply to you. Now for you, that small company limit is 4 crore and 40 crore only. And certain companies will not be considered as foreign company. What are the companies? A holding company, a subsidiary company, a section 8 company, a statutory company, a public company can never be considered as a small company as per section 2 clause 85. That's the definition. In the given case, people, it is a holding company. This is a subsidiary company. So neither can this company nor this company be considered as a small company. Now how will I write? I will first write the definition. First paragraph will always be provision. In the provision, I'll have to define what is small company. The second paragraph will be what is the facts given in the question. Tycoon Private Limited is a holding of Glass Private Limited whose turnover is 1.8 crore, paid up capital is 80 lakh. The question in the fact is whether Tycoon Private Limited or what? Okay, Glass Private Limited is a small company or not. Conclusion: considering the above, because it is a subsidiary company, it can never be considered as a small company. Same thing applies. It's a holding company, it can never be considered a small company. So I will be writing, see, how will my answer be? You are required to examine whether the contention of the company secretary is correct, explaining the relevant provision of the act. My solution will be the contention of the company secretary is correct because it is a subsidiary company or it is a holding company. They can never be considered as a small company, referring to the provision of law. That's how my answer will be. Whatever is given here, put that only in conclusion. Hello, done. In the Flower Fans Private Limited, there are only 5 members. All of them go in a boat on a pleasure trip into an open sea. The boat capsizes and all of them died being drowned. Explain with reference to the provision of Companies Act. Is Flower Fans Private Limited no longer in existence? Further, is it correct to say that the company, being an artificial person, cannot own property and cannot sue or be sued? Remember people, this is nothing but perpetual succession. Members may come and go, but the company will go on forever and ever. So the contention of Flower Plans no longer in existence is wrong. Even if all the members die, the legal heirs will step into their shoes and the company will continue, as the company has perpetual succession. I hope it is clear. Next one. Is it correct to say that the company, being an artificial person, cannot own property and cannot sue? Now people, is it correct to say? It is incorrect. As it is an artificial person, it can enter into a contract. A company is considered as a different person which has a separate legal entity. It can enter into a contract. It can hold properties in its own name. It can sue and be sued. Done. Nitesh Gupta is constructing his house. For this purpose, he entered in a contract with Measures Baba Brick House to supply of 10,000 bricks on 12th August 2023. Measures Baba Brick House has 2 lorries of 5,000 brick capacity. On 12th August 23, one of the lorries was not in working condition, so Measures Baba Brick House supplied only 5,000 bricks and promised Nitesh to supply rest 5,000 bricks on next day. Nitesh Gupta wants to cancel the contract as Measures Baba Brick House did not supply the bricks as per the contract. Measures Baba Brick House gave the plea that no fault has been made from its part, hence the contract should not be cancelled. In this situation, whether Nitesh Gupta can avoid the contract under Indian Contract Act, is it possible? Answer is yes, people, it is possible. Always remember people, what is considered as performance of a contract? On the date of performance, whatever you have agreed, you are supposed to deliver. Lorry not working is not impossibility, it is just an excuse. You can hire one more lorry. It will cost you more, but it is still possible for you to deliver. Agreed, huh? So in case Nitesh Gupta can avoid the contract under Indian Contract Act, answer is yes. I can put an end to that contract. I can say that I don't want the rest of the 5,000 bricks. Whatever has been delivered, for that I will pay. That is only called as what? Quantum merit. For what is delivered, I will pay. That is okay. But can I avoid the rest of it? Answer is yes. It is considered as breach of contract. Clear? Simple? Done. Rahul, a transporter, was entrusted with the duty of transporting tomatoes from a rural farm to a city by Ashwin. Due to heavy rains, Rahul was stranded for more than 2 days. Rahul sold the tomatoes below the market rate in the nearby market, where he was stranded, fearing that the tomatoes may perish. Can Ashwin recover the loss from Rahul on the grounds that Rahul had acted beyond his authority? Similar people, remember, whatever we saw in Indian partnership, if the words used are partners, you have to refer to Indian Partnership Act. If they have not used the word partners, then you will use it in the case of agency. Agency during emergency. In that case, remember, agent will have all the right to bind the principal. Principal will be liable. So principal cannot recover any loss from the agent. Whenever it's an emergency, agent can even act beyond his scope or power. Principal will be liable. That is the answer. A agrees to sell certain goods to B on certain date on 10 days credit. The period of 10 days expired and goods were still in the possession of A. B has also not paid the price of the goods. B becomes insolvent. A refuses to deliver the goods to exercise his right of lien on the goods. Can he do so under Sale of Goods Act? Can he do? Of course, answer is yes. Whenever people, seller is an unpaid seller, and if the goods are still in his possession, then the seller can always exercise right to lien. If the goods are not in his possession, the goods have departed, it is on the way, then you can exercise right to stoppage in transit. In the given case, can he exercise right to lien? Answer is yes, he can exercise. That is against the goods. Against the buyer also, I can always sue for the price of the goods. So I can exercise right of lien on the goods. I can exercise right for the price on the buyer. AB sold 500 bags of wheat to CD. Each bag contains 50 kg of wheat. AB sent 450 bags by road transport and CD himself took remaining 50 bags. Before CD receives delivery of 450 bags sent by road transport, he becomes bankrupt. AB, being still unpaid, stops the bag in transit. The official receiver on CD's insolvency claims the bags. Decide the case. Remember people, whenever if it is right to stoppage in transit, the total agreed quantity is 500 bags. Out of that 50 is already delivered, 450 is still on the way. When can I exercise right of stoppage and transit? Whenever the buyer becomes insolvent and in no other scenario I can exercise. In the given case, as the buyer has become insolvent, the seller has a right to exercise right of stoppage and transit on the rest of the goods which is not yet reached the buyer. As they are still on the way, I can exercise the right of sit on the goods on transit. Hello? Okay. Priyansh purchased some goods from Sumit. He issued a check to Sumit for the sale price on 14th June 23. Sumit presented the check in his bank and his bank informed him on 19th June 23 that the check was returned unpaid due to insufficiency of funds in the account of Priyansh. Sumit sued against Priyansh under the section 138 of Negotiable Instruments Act 1881. State with reasons whether this suit is maintainable. What are they telling you? Priyansh purchased some goods from Sumit. He issued a check for the sale price on 14th June 23. Sumit presented the check in his bank and his bank informed him on 19th June 23 that the check was returned unpaid due to insufficiency of funds in the accounts of Priyansh. Can I sue? Answer is yes. It comes under what, people? It comes under your check bounce case. Section 138 is what? Check bounce case only. Yeah. Yes, I can sue. That is allowed. If you remember in our class, we would have given a timeline also. Within 3 months or the agreed period, you need to go and present the check. Within 30 days of check bounce, you need to give an opportunity to the seller to, buyer to pay the price. That entire thing will come. Okay, next one. Mr. Y, aged 21 years, lost his mental balance after the death of his parents in an accident. He was left with his grandmother aged 85 years, incapable of walking and dependent upon him. Mr. M, their neighbor, out of pity, started supplying food and other necessaries to both of them. Mr. Y and his grandmother used to live in the house built by his parents. Mr. M also provided grandmother with some financial assistance for her emergency medical treatment. After supplying necessaries to Mr. Y for 4 years, Mr. M approached the former asking him to pay back 15 lakh, which has 7 lakh for medical treatment of the grandmother. Y pleaded that he has got his parents' jewelry to sell to a maximum value of 4 lakhs, which may be adjusted against the dues. Mr. M refused and threatened Mr. Y with a legal suit to be brought against for recovering the money. What has happened, people? There is a neighbor and there is one home where there is Mr. Y who is an unsound mind person. This Y has one grandmother also. So she is also not doing well. So this neighbor supports Y for whatever his expenses, and not only that, even for the grandmother's medical cost. The neighbor has helped everything. After 4 years, he is asking to recover the money. I have spent around 15 lakhs. 15 lakhs on both of you. I want you to repay the money. Now, can I get back the money, people? They are asking you, Mr. M, will he succeed in filing the suit of recovery for the money? Answer is yes, he will succeed. Why? Why? Because, people, what type of contract will this be considered as? The claim for necessaries, people. It's a quasi contract. You will be liable. Whatever is the money given or anything served for necessaries for the parties who are incapable of entering into a contract, and the dependence of them. If I have spent money on them, I can recover the money. Yes, I can. What is the maximum amount of money that can be recovered? Remember, you can never recover more than the assets of the person, meaning they will never be personally liable. In our case, this person has jewelry worth 4 lakh. So what if this person has nothing else? Then that's all, people. I'll be only liable to the extent of 4 lakh. Even though you have asked me to pay 15 lakh, I'll be only liable to the extent of 4 lakh if I did not have anything else. But in the question, people, they have clearly given they are staying in their house which is built by his parents, and the parents are no more. That means what? That house also belongs to him only as a part of inheritance. So even that inheritance, that home will also be liable. So I can recover even that home as well. Next one, shall the provisions of above act apply to the medical treatment given to the grandmother as well? Yes, in the quasi contract, whatever is the supplies given to the incapable person and the person dependent on them, I can recover both the whole money. Answer is yes. Good one. Jagannath Oils Limited is a public company and having 220 members, of which 25 members were employed in the company during the period 1st April 2006 to 28th June 2016. They were allotted shares in Jagannath Oils Limited first time on 1st July 2007, which were sold by them on 1st August 2016. After some time on December 2016, each of those 25 members acquired shares in Jagannath Oils Limited, which they are holding till date. Now the company wants to convert itself into a private company. State with reasons whether Jagannath Oil Limited is required to reduce the number of members. Answer is yes, they are required to reduce the number of members, people. The reason is, what has happened? They have purchased, they have sold. After some time on 1st December 2016, each of those 25 members acquired shares of Jagannath Oils Limited, which they are holding till date. Now the company wants to convert its private company. Now what has happened? It's a public company who has 225 members. In this, they are telling you there are 25 employees for whom the company had allotted shares, and they have sold it also subsequently. And after another 2 years time, they have purchased it from the market. Now they're asking you whether will they be counted in the count of employees or not. I will not be counting them as our employees because they sold it. They are not holding it anymore. They sold it and they again purchased it. Would your answer be different if about 25 members were the employees in Jagannath for the period from 1st April 2006 to 28th June 2017? Correct? So if at all till 2017, if they were the employees in Jagannath for the period from 1st April, what is that? That means if they had not sold anything, then yes, people, I will not include them in the number of members. Then this 220 members, including the employees, I will not count them in the limit of 25. Because what does the private company definition say? The maximum number of members in a private company is what? 200 members. In that, you should not count your employees. Whoever are the employees who were allotted the shares, you should not count them. Now that is what they're telling you, people. If at all they are still, they have not yet sold, they are continuing to hold, then yes, don't count them. If they had sold, people, then yes, you will count them. If they sell and subsequently buy, that will not count. I hope this is clear. Yes, sir. We'll just check it off once. Question is that, the first one, hence, they will be considered as members. Why? Because they were ceased to be employed in Jagannath Oils Limited. Hence, they have to reduce. On the other hand, if those 25 members cease to be an employee on 28 June, they were employed at the time of getting present membership. Hence, they will not be counted as members for the purpose of 200. Clear? Done. What is this? Okay. Sonal went to a jewelry shop. Sonal went to a jewelry shop and asked the sales girl to show her diamond bangles with ruby stones. The jeweler told her that we have a lot of designs of diamond bangles but with red stones. If she chooses for herself any special design of diamond bangles with red stones, they will replace red stones with ruby stones. But for ruby stones, they will charge some extra cost. Sonal selected a beautiful set of designer bangles and paid for them. She also paid the extra cost of ruby stones. The jeweler requested her to come back a week later for delivery of those bangles. When she came back after a week to take delivery of the bangles, she noticed that due to ruby stones, the design of the bangles has been completely disturbed. Now she wants to terminate the contract and thus ask the manager to give her money back. But he refused for the same. Answer the following questions as per Sale of Goods Act. State with reasons whether Sonal can recover the amount from the jeweler. Can Sonal can recover? Answer is yes, can recover. What would be your answer if jeweler says that he can change the design as to his original form, but he will charge extra cost for the same? Yes, people, if jeweler says that he can change the design, yes, that is really good. But can he charge extra for it? Answer is no, he cannot charge extra for it. So this is, Sonal can recover the amount from the jeweler. Answer is yes. This answer is no, he cannot charge extra. Simple, huh? Okay, next one. An employee, Mr. Karan, signed a contract with his employer, company ABC Limited, that he will not solicit the customers after leaving the employment from the company. But after Mr. Karan left ABC Limited, he started up his own company, PQR Limited, and he started soliciting the customers of ABC Limited for his own business purpose. ABC Limited filed a case against Mr. Karan for breach of employment and for soliciting their customers for own business. Mr. Karan contended that there is a corporate veil between him and his company and he should not be personally held liable for this. In this context, the company ABC Limited seek your advice as to the meaning of corporate veil and when the veil can be lifted to make the owners liable for the acts done by a company. What is this, people? Nothing but people lifting of corporate veil. If you guys remember the case also, the case is what, people? The Clifford Motor Company versus Horn. There was in this case, what happened, people? The company and the employee, they entered into an agreement. What is that? A company has told employee, if you leave the company anytime soon, after you go, you're not supposed to do the same business as the company does, and you're not supposed to take our customers from us. Say, for example, whatever, for a relevant period, 3 years, 4 years, as the case may be. Now, what did this person do? After going out, he has started one own company. That own company is called as ABC Limited. Let us imagine. ABC only, yeah. No, some other company. ABC Limited is this company's name. Let us imagine XYZ. Now, whichever is a company which hired him, that company sent a notice to this company saying that there's a clear restriction that you are not supposed to take our customers or do the business that we are doing. But the employee, Karan, replied that was a restriction between you and me, not between you and this new company. People, in this case, what happened, people, it will be considered as lifting of corporate wheel. This XYZ Limited and this employee are one and the same. Whatever I could not do directly, I am trying to do it indirectly. Lifting of corporate wheel. Clear? Yes. What is this? State whether the following are partnerships under Indian Partnership Act 1932. X, a contractor, appointed Y, one of his servants, to manage his business offloading and unloading railway wagons. Y was to receive 50% of the profits of the business and also to bear the losses, if any. Is this considered as what, people? Is this considered as a partnership? So technically what they are telling you, state whether the following partnerships under Indian Partnership Act. X, a contractor, appointed by one of his servants to manage his business of loading and unloading railway wagons. Y was to receive 50% of the profits of the business and also to bear the loss, if any. If you ask me, people, they have not framed this right. They have tried to confuse you in this particular case. Where exactly, sir? See, this is not considered as partnership firm. This is a case of partnership because see this answer, this is a model paper they are given. What is the question? Is this considered as a partnership firm? What have they written? Answer is no. But look at the answer. This is model paper, not mine. This is a case of partnership because no mutual agency relationship exists among X and Y. This is a case of partnership because no mutual agency relationship exists among X and Y. Framing is wrong. Yes, sir. So what is the answer? This sharing of profits, this alone cannot be considered as partnership firm. So my answer is no. Essential elements of partnership firm does not exist. There is no agreement. There is no mutual agency, cardinal principle. They have not agreed anything. And the main thing, people, servant. That means what? They are employer and employee clearly given. And hence I will write this is not a partnership. If you ask me, not well drafted. Two firms each having 12 partners combined by an agreement into one firm. Two firms each having 12 partners combined by an agreement into one firm. Yes, possible. A and B co-owners agree to conduct the business in common for a profit. A and B co-owners agree to conduct the business in common for profit. Yes, people, this can be considered as partnership firm, though it is co-ownership. They agree to conduct the business in common for a profit. Technically, co-ownership cannot be considered as partnership, but provided I can write here with an assumption. Now, what is that? See, they have written it as yes. Technically, they have tried to confuse you because what will you write? If it is co-ownership, what is the first thing that strikes your mind? No, it is not partnership. But why do we call co-ownership as not partnership? Because in co-ownership, there will be no business involved. They won't discuss anything. There will be rent coming, they will be dividing, that's all. They won't be doing business, there will be no strategies. Here, see, they are conducting the business, that's the reason. Yes. Some individuals form an association to which each individual contributes 500 annually. The object of the association is to produce clothes and distribute clothes free to the war widows. People remember, partnership means you have to earn the profits. Free means no, not a partnership. A and business is mandatory. A and B co-owners share between themselves the rent derived from a piece of land. See the difference. They are only deriving the rent. Is there a business? No. Any strategies? No. This is not a this is not a partnership. That's just a co-ownership. A and B buy commodity X and agree to sell the commodity, sharing the profits equally. A and B buy commodity X and agree to sell the commodity, sharing the profits equally. This is not a partnership. Why? This is not, there is no business. There is no agreement. There is no mutual agency. We both are buying 1 gram of gold. We are selling it at a higher price. How can this be a partnership? There is no business involved. 10 major persons form an association to which each member contributes 10,000. The purpose is to produce medicines. Same thing? No. BC Private Limited and its subsidiary KL Private Limited are holding 90,000 and 70,000 shares respectively in PQ Private Limited. BC, KL, PQ are holding 90,000 and 70,000. 90,000, 70,000. The paid up share capital of PQ is 30 lakhs. That is 3 lakh shares. Analyze with reference to the provision of Companies Act whether PQ Private Limited is a subsidiary of a BC Private Limited. Is it a subsidiary of BC Private Limited? Okay. BC Private Limited and its subsidiary KL Private Limited. They have clearly given KL Private Limited is a subsidiary of BC. So together how much they are holding here? 9 plus 7 how much? 16. That is mean they are holding 1,60,000, more than one half. Yes people, it is a subsidiary of BC. What would be your answer if KL Private Limited holds 1,60,000 shares in PQ? Let us imagine not 90, not 70. They are telling 1,60,000 is directly held by KL only. Even this is also a subsidiary company. Why? What is a subsidiary company? A company in which the holding company alone or together with its subsidiaries holds more than one half the total voting power, or it is a deemed subsidiary company. What do I mean by deemed subsidiary company? Deemed subsidiary company means like this: X, Y, Z. X is a holding, Y is a subsidiary. Let us imagine if Y is a holding, Z is a subsidiary. They will be calling Z as a deemed subsidiary of company X. Yes. Okay, Mr. R extended a loan to Mr. D with X, Y and Z as sureties. Each surety executed a bond with varying penalty amounts. X with a penalty of 10,000, Y with 20,000, Z with 40,000. In the event of Mr. D's failure to repay the borrowed money to Mr. R, examine the liabilities of the sureties in accordance with the Indian Contract Act. When Mr. D defaults to tune of 42,000, I need to pay 42,000 people surety. There are 3 people. One says 10k, one says 20k, one says 40k. How much have I defaulted? 42,000. Now what will be my liability? People up to 10,000, all of them are liable. First to share it equally. Now still how much is there? Another 12,000 we need to pay. Share that 12,000 between these 2 people equally. So how much will we be liable? This person will be liable to 10k, this person will be liable to 16k, this person will be liable to 16k. Additionally, assess the situation if there is no contractual arrangement, meaning we have not agreed on anything like 20k, 10k and all. Nothing if is agreed, then we will share it equally. So 42k divided by 3. Simple one. X agrees to pay Y 1 lakh rupees if Y kills Z. To pay Y, X borrows 1 lakh from W, who is also aware of the purpose of the loan. So X agreed to pay Y if Y kills Z. And X has borrowed money from W, who is also aware. Now Y kills Z, but X refuses to pay. X also to repay the loan to W. Explain the validity of the contract between X and Y, between X and W. Everything is illegal, people. A contract which is connected to an illegal agreement and you are also aware of it will also be tainted with illegality. Yes, it's a void it's a void agreement. It's an illegal agreement. Sorry. What is a bill of exchange? Okay. An auction sale of certain goods was held on 7th March 2023 by the fall of hammer in favor of the highest bidder X. The payment of auction price was made on 8th March 2023, followed by delivery of goods on 10th March 2023. Based upon the provision, decide when the auction sale is complete. Auction sale, when is it complete, people? Whenever the auctioneer, when he communicates the purchase, that is when the sale is complete. It can be clap, it can be ringing of a bell. If they are given in exam, it will be most of the cases it will be hammer. So hitting the hammer thrice, on that day only the sale is complete. When the money is paid, when the delivery is made is irrelevant. So it is complete on 7th March 2023. Done. I hope it is working. I hope it is revising for you. Certain goods were sold by sample by J to K, who in turn sold the same goods by sample to L, and L by sample sold the same goods to M. M found that goods were not according to the sample and rejected the goods and gave a notice to L. L sued K and K sued J. Can M reject the goods? Also advise K and L as per the provisions of Sale of Goods Act. Can we reject, people? Under what provisions does this come under? This comes under, people, whenever a sale of goods happen by sample, a person should always be given an opportunity to consider, for a person to check the bulk. Yeah, until that is done, whenever the goods are sold by sample, the ownership does not get passed. So in our case, I have an opportunity to check. The bulk has to correspond to the sample. If it does not correspond, I have a right to reject. So that will be my right. Yes. If you want, you can see the detailed answer once. Generally, people will keep asking this. According to auction sale is 64. Okay. As per the Sale of Goods Act, in a contract of sale by sample, there is an implied condition that the bulk shall correspond with sample. See, that is my provision. This is where my law will be. I have to write as it is, what the law says. The buyer shall have reasonable opportunity of comparing the bulk with the sample. In this case, M received the goods by sample from L. But since the goods were not according to the sample, M can reject the goods and can sue L. Possible. With regards to K and L, L can recover damages from K and K can recover damages from J. But for both K and L, it will not be treated as breach of implied condition as to sample, as they have accepted and sold the goods according to section 13(2) of Sale of Goods Act. What is that? If you have taken and if you have further sold, people, it will be considered as what? It is considered as acceptance only. But can I sue for damages? Answer is yes. That is, because of you, if we are suffering any loss. For that, yes. Now, for example, M has filed a case on us. For that, we are liable. But in this sample case, if I have accepted and if I have further sold, that means I have accepted my ownership. So I cannot do anything for this sale. Clear, huh? Okay. Utkarsh purchased some goods from Saksham for 50,000 on 14th August 2023. Saksham drawn a bill of exchange on Utkarsh and sent to him for acceptance on the same day at 3 p.m. Utkarsh requested Saksham to allow him some time for acceptance. Saksham allowed him 48 hours for acceptance. Utkarsh could not accept till 16th August 2023. Saksham treated the bill as dishonored for non-acceptance. Referring to the provisions of Negotiable Instrument Act, whether the bill of exchange was dishonored due to non-acceptance. They've asked a technical, what is this? Whenever a bill is given, you will have 48 hours to accept the bill. And remember that 48 hours does not include, people, public days, public holidays. Now in your case, if you look at it, 14th August, that is when the bill was given. People, Independence Day will come on 15th August. Now people, I will not count that. So the 16th August is not within time. Still 48 hours is not yet done. So on that ground, people know whether the bill of exchange was dishonored. The answer is no. It is not yet dishonored because the 48 hours period is not over. The 48 hours will be considered as the business, I mean, the public holidays will be excluded. Yes, all of you, is this clear? Since 15th August is a public holiday, his 48 hours would end on 17th August 2023 and not on 16th August. Hence, the bill could not be treated as dishonored. Hello. Done. Done, 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 done. But I have a class in next half an hour. In light of provisions of Indian Contract Act 1872, answer the following. Mr. S and Mr. R made contract wherein Mr. S agreed to deliver paper cup manufacturing machine to Mr. R and to receive payment on delivery. On the delivery date, Mr. R did not pay the agreed price. Decide whether Mr. S is bound to fulfill his promise. Answer is no. Reciprocal promises. The promisee is not bound to perform if the promiser is not willing to perform. If you have not paid the price, why will I give you the machine? The answer is no. Mr. Y has given loan to Mr. G of 30 lakh. Mr. G defaulted the loan on due date and debt became time barred. After the time bar debt, Mr. G agreed to settle the full amount to Mr. Y. Whether acceptance of time bar debt contract is enforceable? Answer is yes. Where does it come? Exceptions to quid pro quo. So considerations which are valid even with, contracts which are valid even without consideration. There you would have seen a promise to pay a time barred debt. Yes, it is enforceable. A and B entered into a contract to supply unique item, alternate of which is not available in the market. A refused to supply the agreed unique item to B. What directions could be given by the court? What is this, people? Breach of contract. What will be my rights? Whenever A has agreed to sell certain goods to B, what type of goods? These goods are very unique. You are not going to get an alternative in the market. In such case, always remember the court will order for something called as what? Suit for specific performance. That means money will not satisfy B's need. You have to supply this goods only. So money will not be the damage. The money will not be a remedy. I will have to supply the goods only. That itself will be my remedy. Clear? Yes, sir. Okay. No limit private company is incorporated as unlimited company having share capital of 10 lakh. One of its creditors, Mr. Samuel, filed a suit against a shareholder, Mr. Innocent, for recovery of his debt against no limit private company. Mr. Innocent has given his plea in the court that he is not liable as he is just a shareholder. Explain whether Mr. Samuel will be successful in recovering his dues from Mr. Innocent. Samuel will not be successful in recovering his dues. Why? What is the procedure? If you are an unlimited company, correct. What do you mean by unlimited company? The shareholders are unlimitedly liable until the complete debt of the company is repaid. The shareholders' liability will not come to an end. But as a creditor, what is your duty? The creditor should first file a case on the company. The company will have first its assets. The company will first use that assets to repay the creditors. Let us imagine if that is also not sufficient, then the company will give a notice to all its shareholders, not only one. In our case, there is only one person called Innocent or Samuel. Innocent. Why you only recover from one shareholder? Why not everyone else? So the company will send a notice to everyone. They will say, people, our total liability is 10 lakh. Can you all contribute it equally? Say 2 lakh each. But in this case, what has this person done? Directly filed a case on Mr. Innocent for the entire 10 lakh. Is this the right route? Answer is no. This is the right route. Hello. Done. A company registered under Section 8 of Companies Act has been consistently making profits for the past 5 years. Section 8 company. After a change in the management structure, few members contended that they are entitled to receive dividends. Section 8 company, can they declare dividends? Answer is no. Can the company distribute dividend? If yes, what is the maximum percentage? Answer is no, they cannot. Also, to discuss along with other regular matters, the company held a general meeting by giving only 14 days notice. Is this valid? Answer is yes, it is valid. In the case of Section 8 company, they will only give 14 days notice. Yes, it is valid. This is a tricky one. Okay, next one. Mr. G sold some goods to Mr. H for certain price by issue of an invoice, but payment in respect of the same was not received on that day. The goods were packed and lying in the godown of Mr. G. The goods were inspected by H's agent and were found to be in order. Later on, the dues of the goods were settled in cash. Just after receiving cash, Mr. G asked Mr. H that goods should be taken away from his godown to enable him to store other goods purchased by him. After one day, since Mr. H did not take the delivery of the goods, Mr. G kept the goods out of the godown in an open space. Due to rain, some goods were damaged. Referring to the provisions of Sale of Goods Act, analyze the above situation and decide who will be held responsible for the above damage. Will your answer be different if the dues were not settled in cash and are still pending? People always remember, people, risk prima facie transfers with ownership. Whenever the agent came and agreed, inspected, the goods were packed and lying in the godown. See, everything is done. And the goods were inspected by agent and were found to be in order. That's all, people. The contract is entered because the goods are in deliverable state. When the goods are appropriated, the ownership is passed. So whether the payment is made or not, people, it is irrelevant. Who will be liable? It is the buyer only who will be liable. But remember, the seller's duty as a bailee will not come to an end. I have to take proper care of the goods. But here in this case, have I taken proper care? Answer is yes, I have taken proper care. Why? I have clearly told you. If you do not come and collect the goods, I have to keep other goods also in my godown. Once the sale is done, am I mad or what to keep the goods in the godown? I've clearly instructed you and you did not come. So it is your responsibility. The seller has taken enough care. Beyond that, the seller will not be liable. Whose liability it is? It is always H's only. H will be liable. I hope this is clear. PQR&S are the partners in measures PQRS and Co., a partnership firm which deals in trading of washing machine of various brands. Due to conflict of views between partners, P and Q decided to leave the partnership firm and started competitive business on 31st July 2023 in the name of measures PQ and Co. Meanwhile, R&S have continued using the property in the name of PQRS and Co., in which P and Q also has a share. Based on the above facts, explain in detail the rights of outgoing partners as per Indian Partnership Act and comment on the following. Right of P and Q to start a competitive business. Can they start, people? Answer is yes. An outgoing partner can start a competitive business subject to the agreements. But just that you cannot use the firm's name after going forward. After going out, you are not supposed to use the firm's name. But remember, people, can I continue a competitive business? Yes, if there is no restriction, why not? I can. There is no problem in that. Rights of P and Q regarding the share in property of PQ and RS. People, remember, whenever the partners are outgoing, after the partners have resigned or if they have stepped away, if the partners, that is the previous partners, if they still continue the partnership from without settling their share of profits, then remember, people, whatever is the money you are earning, you have to share the percentage with them as well because you have not yet settled. So in this case, P and Q will be eligible for a share in the profits earned by PQRS. Done. MNP Private Limited is a company registered under Companies Act with a paid up capital of 5 crore, turnover of 35 crore. Explain the meaning of small company and examine whether MNP can avail the status of small company. It's a private company having a paid up capital of 5 crore. Maximum is 4 crore, so it's not a company. What will be your answer? The turnover of the company is 45 crore. No, it's not a small company. Define misrepresentation and fraud. Okay. Where is this? Ram sells 200 bales of cloth to Sham and sends 100 bales by lorry and 100 bales by railway. Sham receives delivery of 100 bales sent by lorry, but before he receives a delivery of 100 bales by railway, he becomes bankrupt. Similar people, goods in transit, whatever we had seen. For the 100 goods, you can exercise the right of transit. Classify the following transaction according to the types of goods. A wholesaler of goods has 100 bales in his godown. He agrees to sell 50 bales and these bales were selected and set aside. Has 100 bales in his godown. He agrees to sell 50 bales and these bales were selected and set aside. People, this will be considered what people? Ascertained goods because they are already selected and set aside. A agrees to sell B 1 packet of sugar out of the lot of 100 packets lying in the shop. This will be what people? This will be considered as what? Ascertained goods because it will be separated from 100. Yes. D agrees to sell to S all the apple which will be produced in his garden this year. Future goods. The packets are unascertained. Whatever is going to be separated will be ascertained. Explain whether the agency shall be terminated in the following cases. A gives authority to B to sell A's land and to pay himself out of the proceeds. The debts due to him from A. Afterwards, A becomes insane. A appoints B as A's agent to sell A's land. B, under the authority of A, appoints C as agent of B. Afterwards, A revokes the authority of B but not of C. What is the status of agency of C? Can I recover this people? The answer is no. Wherever the agency has a personal interest involved, then you cannot revoke such agencies. So in this case, I told him you can sell the land and you can recover the money from that land. Wherever an agent is personally interested, you cannot revoke such agencies. Yeah, but A becomes an insane. Insane means people unsound mind. Automatically agency will come to an end, but you cannot revoke it on your own. That is not possible. A appoints B as A's agent to sell A's land. People, sub-agent is not valid at all, people. So if I have revoked B, that's all. I need not have to communicate anything to C and all. That will also automatically will get revoked only. I do not have to communicate anything to C. Next one, Advik purchased a mobile from Banu. He issued promissory note to Banu which was payable on demand but no specific place for payment was mentioned on it. On maturity, Banu did not present the promissory note for payment. As the promissory note was not duly presented for the payment, whether Advik could be discharged from liability under the provisions of Negotiable Instrument Act? What is the provision, people? When is presentment excused by law? Whenever, people, it's a delivery instrument or demand instrument. In such case, people, the delivery of the instrument is not needed. In such case, I can get the money even without delivery. So, non-presentment cannot be considered as people dishonor and all. So, you are not discharged. You are liable to pay. Yes, sir. Payable on demand. It is, remember, always it is considered as if it is payable on demand. Then you need not have to present it. It is excused from presentment. Shiva gave a gift of 21,000 to his sister through a check issued in her favor on the occasion of Raksha Bandhan. Afterwards, Shiva informed his sister not to present the check for payment and also informed the bank to stop the payment. Examine the provisions of Negotiable Instrument Act 1881. Decide whether Shiva's act constitute an offence under section 138 of the act. Answer is no, people, because Shiva has given it as a gift. The check has given it as a gift. Section 138 will come into picture only when it is your liability. It can never come in the case of gift and all, people. It has to be a debt. Yeah, that means what? You need to, you should have made the payment towards a settlement of any liability, debt, or towards any transaction. It cannot be gift. So in this case, no, it is not a scenario of 138 because a gift will never come under check bounce. 138, no, not possible. Okay. Rahul found a smartwatch in a restaurant. He inquired about all the customers present there, but the true owner could not be found. He handed over the same to the manager of the restaurant to keep till the true owner is found. After a week, he went back to the restaurant to inquire about the smartwatch. The manager refused to return it, saying that it did not belong to Rahul. In the light of Indian Contract Act, can Rahul recover? Answer is yes. Why? Remember, in the case of goods which is lost, the finder of the lost goods will become the owner of the goods until the true owner is found, provided whoever is the person who had the goods in possession, I will pay him whatever are the necessary charges I need to pay. After that, people, I will be considered as owner of the goods. So in this case, Rahul can recover the smartwatch. You can quote a case law also here, that is Hallin versus Howler. Next one, Mr. Vikas, a businessman, has been fighting a long drawn litigation with Mr. Neeraj, an industrialist. To support his legal campaign, he enlists the service of Mr. Manoj, a judicial officer, stating that amount of 10 lakhs would be paid to him if he does not take up the brief of Mr. Neeraj. Mr. Manoj agrees, but at the end of litigation, Mr. Vikas refused to pay Mr. Manoj. Decide whether Mr. Manoj can recover the amount promised. Can he recover? Answer is no. Why? Because these are the agreements opposed to public policy. These are the agreements opposed to public policy because you are coming in the path of justice. So can you do it? Answer is no. Any such agreement made, you cannot recover the money. It will be considered as void agreement. Yes, sir. Okay. Samyak was appointed as an employee of Moonlight Timber Private Limited on the condition that if he have to leave his employment, will not solicit. Same thing, people. What is that? Gifford Motor Company versus Horn. Same thing. Pacific Motors Limited is a government company. Rama Auto Private Limited is a private company having share capital of 10 crore. Rama Auto has paid up share capital of 10 crores in the form of 10 lakh shares. Pacific Motors is holding 5 lakh. Pacific holds 5 lakh. In Rama Auto Private Limited claimed the status of government company, advises legal advisor whether Rama Auto Private Limited is a government company under the provision of people. It has to be 51% people. In this case, it is exact 50%. So I cannot consider this as a government company. What is government company? Whenever there is a what is that? 51% or more is held by state government, central government, state and central or state governments. And remember, subsidiary of a government company will also be considered as a government company, but it is not a subsidiary company. It should be more than 1/2. No, I'm exactly holding 5 lakhs. So where is it a subsidiary? So it's not a subsidiary. Measure Seema went to the local rice. Ms. Seema went to the local rice and wheat wholesale shop and asked for 100 kgs of basmati rice. The shopkeeper quoted the price of the same as 125 per kilo, to which she agreed. Ms. Seema insisted that she would like to see the sample of what would be provided to her by the shopkeeper before she agreed upon such a purchase. The shopkeeper showed her a bowl of rice as a sample. The sample exactly corresponded to the entire lot. The buyer examined the sample casually without noticing the fact that even though the sample was that of basmati rice, it contained a mix of long and short grains. The cook, on opening the bag, complained that the dish, if prepared with the rice, would not taste the same, as the quality of rice was not as per the requirement of the dish. Now, Ms. Seema wants to file a suit of fraud against the seller, alleging him of selling a mix of goods and cheap quality rice. Will she succeed? Answer is no. Why? because whenever the goods are sold by sample, and if an opportunity is given to the buyer to check it, and you need to check it, does the bulk correspond to the sample? In this case, answer is yes, you were negligent. So answer is no, you will not be successful. Yes, sir. What would your answer be in case Ms. Seema specified her exact requirement as to the length of the rice? If Seema has specifically said that the length of the rice I need is long grain, and long and short both are mixed, in that case, people, this will become quality or fitness. I've clearly made you known my purpose, and it has to serve the purpose. If that is not served, but remember, you should have also checked if quality is not corresponding to the bulk, but if you had an opportunity to check, then the answer would not change. Clear? Okay. Mr. Ram and Mr. Rahim are working as teachers in Ishwar Chand Vidyasagar Secondary School and are also very good friends. They jointly purchased a flat which was given on rent to Mr. John. It was decided between landlords and tenant that the rent would be 10,000 per month, inclusive of electricity bill. It means electricity bill will be paid by landlords. The landlord by mistake did not pay the electricity bill. Due to this, the electricity department cut the connection. Mr. John has to pay the electricity bill, that is 2,800 and even 200 rupees as penalty. Mr. John claimed 3,000 from Mr. Ram, but Mr. Ram replied that he is only liable for 1,500. Is it right? Answer is yes, because they are co-owners. They are not partners. Because what? They are only renting out a property. There is no business between them. They are not acting, no strategies, no separate bank accounts and all. So yes, people, Ram will be liable only for 1,500. The rest of the 1,500 you have to collect it from Rahim. But if it is a partnership firm, yes, you could have collected from one partner, correct? But because it is not a partnership firm, no, this will not succeed. Next one, Mr. R, a manufacturer of toys, approached MNO Private Limited for supply of raw material worth 1,50,000. Mr. R was offered a credit period of 1 month. Mr. R went to the company prior to the due date and met Mr. C, an employee at the billing counter, who convinced the former that the payment can be made to him as the billing cashier is on leave. Mr. R paid the money and was issued a signed and sealed receipt by Mr. C. After the lapse of due date, Mr. R received a recovery notice from the company for 1,50,000. Mr. R informed the company that he had already paid the above amount and, being an outsider, had genuine reason to trust Mr. C, who had claimed to be an employee and had issued him a receipt. The company filed a suit against Mr. R for non-payment of dues. Discuss the fate of suit and liability of Mr. R towards the company as on the current date in consonance with the provision of Companies Act. Would your answer be different if receipt under the company seal was not issued by Mr. C after receiving payment? There are two questions. So what has happened? There is a person, let us imagine R, he had to pay some money to the company when he went. That day the relevant person was not there. There was one more person called C. He has paid money to C. C has also given him a receipt under the company seal. Now company, after coming back, C has not deposited that money to the company. Company, after some days, they sent a notice to R. Why have you not paid the money and you are liable now to recover, pay the money to the company? The question is R liable? Answer is no. Doctrine of indoor management. I have received a settlement, an invoice with a receipt with a company seal on it. That means it is company's responsibility. How you guys manage in-house is left to you guys. Whether C gave this to you or not is your headache, not mine. But people, if company, C did not give a, company seal. He just signed and gave. Then yes, people, you are liable because you are also supposed to have some due diligence. You should have not acted in negligence. You should also check to whom you are paying the money. So if you did not get an invoice under a company seal, then yes, people, you are liable. Company is right in holding you liable. Doctrine of indoor management will not apply. Mr. A, the employer, induced his employee Mr. B to sell his one-room flat to him at less than market value to secure promotion. Mr. B sold the flat to Mr. A. Later on, Mr. B changed his mind and decided to sue Mr. A. Can it happen? Answer is yes. What is it? It comes under undue influence. Mr. S promises Mr. M to paint a family picture for 20,000 and assures to complete his assignment by 15th March 2023. Unfortunately, Mr. S died in road accident on 1st March 2023 and his assignment remains undone. Can Mr. M bind the legal representatives of Mr. S of the promise made by Mr. S? Suppose Mr. S had promised to deliver some photographs to Mr. M on 15th March 2023 against a payment of 10,000, but he dies before that day. Will his representatives be bound to deliver the photographs in this scenario? Two questions are there. One, painting, which involves personal skill and talent. In such case, if at all the promiser dies, the contract will die with him. The contract becomes void contract. In that case, if at all 20,000 is taken, the legal representatives have to return the 20,000. But can you force the legal representatives to paint? How can they paint it? No. In the second case, what if instead of paintings, he has promised to deliver some photographs in his home, meaning some wall frame, something? Does it require a special skill or something? No. I just said there is one photo in my home, I'll deliver. In this, yes, legal representatives will be liable because there is no special skill, trust, confidence involved. So even if the promiser dies, the legal representatives can be held liable. I hope you know I don't know how many questions we have seen. Yeah, good, no? Just sitting back and seeing so many questions. What if same question is asked in the exam? I'm telling you, at least there is a scope of 15 marks coming from the questions we discussed. In the same channel, people, I have discussed 5 years RTP and MTP. Yeah, put together, everything put together. Watch it. It's there. It's on YouTube. Make use of those things. These are for you guys only, no? Yes? Okay. Next one. Rachit arranges an auction to sell an antique wall clock. Deepa, being one of the bidders, gives the highest bid. For announcing the completion of sale, the auctioneer falls the hammer on table, but suddenly hammer breaks and damages the watch. Sale is not complete, people. In auction sale, when is the sale complete? There should be a sale. The hammer should have hit the table thrice. Before that only, if it has broken, people, then yes, the sale is not yet complete. X contracted to sell his car to Y. They did not discuss the price of the car at all. People, whatever we have already seen, whatever is reasonable you have to give. If it is, what is that? If we have agreed that third party will decide the price. Shankar drew a check in favor of Surender. After having issued the check, Shankar requested Surender not to present the check for payment and gave a stop payment request to the bank. People, as long as it is not a gift, they have not given Y. If it is for a legally enforceable debt, then yes, it is a section 138. Again, it is coming under your check bounce case. Okay, we'll try to do this as the last one. Yeah. Okay, Mr. Chetan was traveling to Manali with his wife by bus of Himalayan Travels Private Limited. Due to some technical default in the bus, the driver has to stop the bus in midway in cold night. The driver advised the passengers to get to the shelter in the nearest hotel, which was at a distance of only 1 kilometer from that place. The wife of Mr. Chetan caught cold and fell ill due to being asked to get down, and she had to walk in the cold night to reach the hotel. Mr. Chetan filed a suit against the Himalayan Travels Private Limited for damages for personal inconvenience, hotel charges and medical treatment for his wife. Explain whether Mr. Chetan would get compensation. Answer is, people, personal inconvenience, yes you will get. Hotel charges, yes you will get. Medical treatment, you will not get. Why? Ordinary damages. Whatever is directly proportionate you will get, not a far-fetched one. That day, people, let us take for example 100 passengers might have got down. Would everyone have got cold? No. So that means this is an exception scenario. Clear? Sahil sells by auction to Rohan a horse which Sahil knows to be unsound. The horse appears to be sound, but Sahil knows about the unsoundness of the horse. Is his contract valid in the following circumstances? If Sahil says nothing about the soundness of the horse, is it valid? Answer is yes, because the seller is not liable to disclose any truth. It is the buyer's responsibility to check before you buy. Caveat emptor. If Sahil says nothing about it to Rohan, who is Sahil's son? So to my own son I have not disclosed anything. In this case, is it fraud? Answer is yes. Why? Fiduciary relationship. When a son is buying something from a father, he buys it with trust. He will believe that father does not cheat. So in that case, even if you remain silent, it will be considered as fraud. It will be considered as fraud. If Rohan says to Sahil, if you do not deny it, I shall assume that the horse is sound. Is this considered as fraud? Answer is yes, because you have a duty to speak here. He has clearly told, if you do not say anything, I will assume that the horse is right. If you do not say anything, I'll assume that the horse has no problem. Now if you keep quiet, then people, silent is equivalent to an accept. Silence is assumed as an acceptance. ABC Limited has allotted equity shares with voting rights to XYZ Limited worth 15 crores during financial year. After that, total paid up equity share capital of ABC Limited is 100 crore. Define the meaning of associate company and comment whether ABC Limited and XYZ Limited would be associate company as per provision. ABC has allotted equity shares with voting rights to XYZ worth 15 crores. In 23-24, after that the total paid up equity capital is 100 crore. People to become a associate company, 20% should be there. That is minimum 20 crore should have been there. In this case, no. MTK Private Limited is a company registered under Companies Act 2013 on 5th Jan 2022. The company did not start its business till 31st July 2024. Identify under which category MTK Private Limited company is classified. What is this, people? Inactive company. Technically nothing but dormant company. A company which is incorporated and sitting idle, not carrying on any business. We call such companies as what? Dormant company. Basically inactive company. Mr. Manoj was running a shop selling a good quality washing machine. Mr. Vivek came to his shop and asked for washing machine which is suitable for washing woolen clothes. Mr. Manoj showed him a particular machine which Mr. Vivek liked and paid for it. Later on, when the machine was delivered to Mr. Vivek's house, it was found that it was the wrong machine and also unfit for washing woolen clothes. He immediately informed Mr. Manoj about the delivery of the wrong machine. Mr. Manoj refused to exchange the same, saying that the contract was complete after the delivery of the washing machine. With reference to the provision of sale of goods, I discuss whether Mr. Manoj is right in refusing the exchange of washing machine. People, the guideline answer given by the institute here, according to me, is wrong. The seller has made known the purpose to the buyer has made known the purpose to the seller. It is to specifically wash woolen clothes. Can you see this? But the institute has answered this is as per description because he is saying good quality washing machine. But the washing machine which he delivered was not of a good quality, it seems. Yeah, I believe that's where simply for the sake of it, the question should not be pulled is what I believe. But yes, according to me, this fits more in quality or fitness. When a buyer has made known the purpose to the seller and the buyer believes in the seller's decision, then people in that case, what will happen? If at all it is not serving the purpose, I have a right to recover the money. Yeah. Mr. Suraj sold his business to a cotton production company, CPL Private Limited, in which he held all the shares except one, which was held by his wife. He is also the creditor in the company for a certain amount. He also got the insurance of the stock of cotton of CPL Private Limited in his own name and not in the name of the company. After 1 month, all the Stock of the cotton of CPL Private Limited were destroyed by fire. What is the case law, people? Macora versus Northern Assurance. Whatever is the contracts entered by the company, it should be in company's own name. Even though the shareholders hold 99%, the properties will not become yours. It should be in the name of the company only. So adding you as a beneficiary is not a right thing. So on that ground, people, Macquarie versus Northern Assurance Company, a separate legal entity. Company is separate from its members. So whatever Mr. Suraj did is not right and not valid. Alpha School is a Section 8 company which started imparting education with sole objective of providing education to children of weaker. Okay. It came to the knowledge of central government that the said school was operating by violating the object of its clause, due to which it was granted Section 8 company license. Describe the powers that can be exercised by central government. What I can do? I can revoke your license. You cannot continue a Section 8 company anymore. I can order to wind you, meaning shut down your business. I can order to merge your company with some other company having similar objects. I can do any of these three. Measures ABC and Associates, a partnership firm with A, B and C as senior partners engaged in the business of curtain manufacturing and exporting to foreign countries. On 25th August 2022, they inducted Mr. P, an expert in the field of certain curtain manufacturing, as their partner. On 10th January, P was blamed for unauthorized activities and thus expelled from partnership by approval of all of the remaining partners. Examine whether the action was right. What should have been the factors considered? People, nothing but people, expulsion of a partner should be in the interest of partnership. The right should be there in the partnership agreement. It should be voted by the majority of the partners. An opportunity of being heard should be given to the person who is being removed. If all the conditions are satisfied, then the expulsion is valid. In this case, yes, it is justified. PowerTech Limited was registered as a public company. There are 230 members in the company as noted below. Who are the directors and their relatives is 190. Employees is 15. Ex-employees is the 10. 5 couple holding shares jointly in the name of husband and wife is 10. And others is 5. The board of directors of PowerTech Limited proposes to convert it into a private company. Also advise whether reduction in the number of members is necessary. Now here I'll show you one thing. Now the basic doubt, which again I would say the companies act as silent, but I'll show you one assumption that the company, ICA has taken. Now what is that assumption, sir? See what they have taken. Okay, in the instant case, PowerTech Limited may be converted into a private company only if the total number of members are limited to 200. Now, what is the total number of members? Directors and their relatives is 190. Couple is taken. There are technically 10 people, right? 5 into 2. So 10. But you have to treat them as one. Joint shareholders have to be treated as one. And others is 5. So technically it is 200. Therefore, there is no need for reduction. Now, what did I say? Assumption. We will not include employees. We will not include ex-employees. People, this directors and their relatives, there is no clarity from the Companies Act point of view on how do you treat directors. We treat director as an employee only. But because here the relative component is there, we do not know how much the director holds, how much the relative holds. So relative to any day you can't take, employee can be excluded, but not the relatives. So on that ground, what we are telling, I will take it as an assumption that the entire 190 will be counted. That's why people, to even help you, they have given this 190 as a higher number. If at all it was 5, 2, 3 and all, then it would have been even more confusing. I hope you got what I am trying to tell. Clear? Huh? So they have not included only these 2 people. Rest of the people they have included. And 10 is counted as 5. Yes. Popular Products Limited is a company incorporated in India having a total share capital of 20 crore. The share capital comprises of 20 lakh equity shares. Again, people, subsidiary company, same logic. Mr. Om Kashyap was a big businessman of Pune city having two sons and one married daughter. He decided to gift his house to his daughter. For this purpose, he called his lawyer at his house and made a written document for such gift. The lawyer advised him to get the transfer document properly registered. When they both were going for registration of document, they met with an accident and both of them died. Later, the daughter found the document and claimed the house on the basis of the document. Explain, is it valid? The answer is no, because people, this comes under whenever there is quid pro quo, natural love and affection. Whenever this contract has to be valid, it should be in writing, it has to be between nearly standing relationship parties, and it has to be mandatorily registered because it is an immovable property. You cannot transfer it without registration. That is what they tried to help you also here. Technically, they should not give you this. You should figure that out. But they have helped you. Understood? So no, she cannot claim. Due to urgent need of money amounting to 3 lakh, Pavan approached Raman and asked him for the money. Raman lent the money on the guarantee of Suraj and Tarun. Pavan makes default in payment and Suraj pays full amount to Raman. Suraj afterwards claimed contribution from Tarun, but Tarun refused to contribute on the basis that there is no contract between Suraj and him. Examine referring to the provisions. People, remember, a surety can always recover money from the co-sureties, possible. And remember, sureties can also recover the money from your debtor as well, subrogation. So you cannot deny people, the co-sureties are liable to contribute equally. Correct? Simran went to a jewelry shop. Ruby stones we have already done. M owes money to N. Therefore, he makes a promissory note for the amount in favor of N. For safety of transmission, he cuts the note in half and posts one half to N. He then changes his mind and calls upon N to return the half of the note which he had sent. N requires M to send the other half of the promissory note. Decide how rights of the parties are to be adjusted. People, remember, whenever you need to negotiate, transfer the instrument, you have to deliver the whole of the instrument. Half and all is not valid. So in this case, it is not a right transfer. It is not a right negotiation. Endorsement should always happen as a full instrument, full delivery. Half and half is not valid. So the rest half also should be given. Clear? Rama executes a promissory note in the following form. I promise to pay a sum of 10,000 after 3 months. Decide whether the promissory note is valid. Answer is no, people, because the name is not mentioned. This becomes similar to a bearer check. So remember, a bearer instrument can only be made by RBI and no one else. We would have seen this in the class also. So on that ground, I would say it is not a valid promissory note because a bearer instrument can only be prepared. That right is there with the RBI, no one else. Yes, people, yes, thank you. I hope you guys learned something. I have another class to catch now. Very best for the exam that is going to come. All the very best. Stay calm. Remember to write for as many marks. Your goal is to touch at least 100 marks. I'm saying you should not leave. Not at least 100 marks. Go as near as 100 marks. It can be 90, 92, 95. But remember, I'm not saying the quantity matters over quality. Of course, write it in a proper way. And try to divide your answer in the same way. People, in the channel, I have clearly uploaded in the last attempt how to present your law paper. I have even written the answers and shown inside the class. That video is there on YouTube. Please search and find it and watch it. It is beneficial for you. I have clearly given you the format in which you have to present and all the mistakes you should avoid. So keep all that in mind and wish you guys the best. Do not panic, it's okay. I know for a fact this attempt is going to be yours. Do not forget to underline whatever is important, provisions, and wherever you guys know the sections number, try to write it. Remember, if you do not write the section number, it's not that they will deduct the marks, but a person who is writing the section numbers may earn an extra mark. Clear, all of you? So thank you so much. See you all. Wish you guys the best. Bye bye.